Hi there, I'm James Dapperchi, and this is Coffee and a Case Note.
Oh, well, we met in high school.
Team, today we are going to have a quick chat about the tension between the New South Wales Supreme Court and the Family Court. And don't worry, we'll actually learn some stuff and it will be quite engaging, I promise. We've got a plaintiff, we have a defendant. The plaintiff is a managed person, which means that the plaintiff has someone else who is taking care of and managing their affairs due to the plaintiff's health and lack of capacity to do so themselves. The defendant in the Supreme Court proceedings is an applicant in family court proceedings, right? So let me refresh your memory a little bit on that, right? New South Wales Supreme Court, our plaintiff, the managed person, which is to say the manager of the managed person, is trying to seek orders to get the defendant kicked out of the plaintiff's apartment. Now, over in the family court, the defendant is seeking orders against the plaintiff that are family law orders for a payment, and that payment is essentially going to be the value of the apartment. That defendant wants that money, and they're going to the family court to try to get that. So let's switch back to the Supreme Court, which is where our judgment today is. We're in the Supreme Court, our managed person is trying to get our defendant kicked out, and what our defendant says is, no, I've got these family court proceedings going on over here, and the family court proceedings relate to this apartment, and so what should happen with these Supreme Court kick me out proceedings is that they should be put on hold. I shouldn't be kicked out until we've dealt with all these issues in the family court. What the defendant also says is, if the managed person needs money, and the background is that the managed person needs money because the managed person has significant needs, including nursing and medical care that need to be paid for. If there's money needed for that nursing and medical care, then the plaintiff has this share in a company that runs a boarding house. You should sell that share before kicking me out of the apartment and selling that. Well, what the Supreme Court does is work through some evidence about that share and finds that in order for the managed person to realise that asset, to get the money for that share, there'd have to be this almost comically complex series of transactions where the board of directors of one holding company would have to appoint a new board to another, a new board to another, a new board to another. So 4 cascading steps through various sets of directors, and it would be extremely complex. And the smoother option, in order for the manager to realise some assets, to get some money for the managed person, would be to kick the defendant out of the apartment and sell the property. What the court says is, including after working through the mechanics of some of the family law issues, he says, yes, that's right. And so what happens is the managed person is allowed to proceed with the managed person's application to remove the defendant, and the defendant does not get to pause or stop or transfer the Supreme Court proceedings over to link up with the defendant's family court proceedings. I hope that very quick little note today was of assistance and value to you. I look forward to speaking again soon over another coffee and in respect of another case note. Cheers.